in some ways, I mean, they could have stopped right there. You know, they didn't need to go beyond that point to rule in favor of Hamdan and to halt the military commissions. But the majority of the court went farther and said, and moreover, the Geneva Conventions, the GPW, Geneva Conventions relating to prisoners of war, it applies, okay? It's judicially enforceable, and it's been violated by this commission. And they held specifically that the military commission was not a regularly constituted court. The regularly constituted military court in the United States is the court-martial, and absent some sort of showing that justified departing from that regularly constituted court, this represents an Article 3 violation. In some ways, it's this holding of the Hamdan decision that gives it broader scope beyond the military commission context. Because if Article 3 applies to the war on terrorism, which really is the holding, then there's some very sweeping language in Common Article 3 that I mean, it bans, for example, violence to life and person, cruel treatment or torture, outrages upon personal dignity, in particular, humiliating and degrading treatment. Okay, outrages to personal dignity, in particular, humiliating and degrading treatment. I mean, I'd suggest that our detainee policy is built on outrages to personal dignity and humiliating and degrading treatment. And if it looks pretty clear that the Supreme Court of the United States has just said that this law, this international law, is U.S. law, and it constrains the conduct of the executive branch of the United States. And it didn't talk about that particular provision. It just talked about Article 3 in general applies, and it talked about it in connection with military commissions, which was set up in our issue. But if Article 3 applies, then the rest of it presumably applies as well, and should, on July 11th, the Department of Defense released a memorandum from a Deputy Secretary of Defense, Secretary England, informing all military branches that Article 3 of the Geneva Convention applies, and we're informing you of the court's opinion in Hamdan, and we are reiterating that all branches of the command are required to comply with Article 3. It goes on to say that, in our view, except with respect to military commissions, we think we are complying with Article 3 and all other particulars, but this is to put all branches of the military on notice about the need to comply with Article 3. I disagree with the assertion that they're complying in all these other respects, but it's that holding in particular that probably has the broadest implications for the war on terrorism generally.